It sounds pretty simple because what it is saying that this is a debt collection agency trying to do it.
That's right.
So this is really simple. Well, to me, it's really simple since debt collecting agency. Did you even make sure that they were had the delegation of authority, the power of attorney to even represent Capital One?
We sent them a letter asking for that information. We did not get it. I sent them a certified mail. I sent them a second letter with an attached affidavit saying, the second letter said, I requested all this information. You have not provided it. And then I attached an affidavit saying that I did not receive any of this information.
Right. Well, like I said, I seen you guys did a thing to dismiss, and part of me is like, don't dismiss it, because you want to turn around and sue them if they're committing barratry.
Okay.
So you don't want to dismiss it just yet.
Yeah, well, we did. That's good. We just was preparing we wanted something to.
We were trying to get the documents ready for the pipeline. We have not done anything with that yet.
We didn't file any of those papers. We're just getting them ready for.
Yeah, good. Right now, I seen that you folks had a thing that said motion to dismiss, and I'm like, you know what? Just let it hang there for a little bit. Because, like I said, now that you're talking to me and getting Greg on involved with this thing too, what I told Greg earlier, I said, no. I said, you know what? Let this case still flounder there. Keep them on a hook for a little bit there because they keep pushing this thing forward. And unless they could show like a delegation of authority and an affidavit, and then they could have to bring up the bill of particulars. And if they're not producing all this stuff, it's giving you a little bit of time to get ready to sue them.
Yeah, well, that's true. I think they do have some responsibility. We sent them two proof of claims, which they just completely ignored them, didn't answer them at all, and then we sent an affidavit.
Yeah, I'm not worried about any of that stuff like that. I mean, that's nice, the big fancy words you're using like that, but that's, to me, it's really simple. It has to be down there in the court case file. It has to be down there. All the evidence that they're going to bring forth before the court is good. Regardless if they're not answering you, that's fine. But did they put it all into the court case file and say, like, if you wanted to actually go by rules, of course, like Rule 5A, all parties have to be given all the documents in which they're going to move the court. Now, see, what they could say is they gave you all of the documents. So just because you think they're ignoring you, they're going to swear up and down in court that they didn't ignore you and they mailed it exactly to the mailing address that you provided for them. So, see, you think that they didn't put all that information into the court. When was the last time you actually went down to the court case file and actually visited?
I thought that it was necessary.
You hear what he's saying? We have to go down and check the court case at the court.
Okay, well, it was my understanding that if they don't give us the evidence that we have it ahead of time in order to answer our complaint, they cannot enter it later.
Sir, they're going to lie through their teeth and say they gave it to you, okay?
Okay.
Okay, so you try to follow me, okay? Don't worry what you're thinking. This is what I'm saying what they're going to do.
Okay.
So go to the courthouse and check the official record.
You have to physically hold the case file in your hand and tell the court clerk lady, I need to see through this court case file. And if she gives you a hard time and you say, look, you know what I need you to do, lady? I need you to give me a certified, complete copy in chronological order every single document in this case file. So right now, technically, you folks are telling me there's only 2 pieces of paper in this case file. I'm telling you, they might have put 500 pieces of paper in the case file, and they're going to swear up on a stack of Bibles, and they say they did mail it to your address, and just because you're too lazy or too slack, and you can't keep up with your own mailing address stuff, coming to your post office box of mail, that's not the lawyer's problem, and that's what they're going to say.
Okay. All right. We'll go down and check in the morning, and, that's, they...
Right. You physically have to go down there, and the court shall actually, the court clerk, or the clerk of the court, maybe her subordinate, will actually watch you look through the court case file. Like, they'll actually stand there with you. I don't know if they have a big bulletproof screen there where you live.
They won't give us any problem down there.
Okay, so I'm asking for a certified copy in chronological order of the case file.
If they won't let you just take a look at it and thumb through it real quick and see the evidence, like, wow, they didn't send me any of this stuff. Wow, they didn't send us any of this. Wow, we asked them for this, but wow, they didn't send us any of this. And then at least that way you could go into court and say, they did not send us any of this.
Okay.
Well, Carl, isn't that where the affidavit would come in, that it says that we did not receive any of that and it's notarized?
No, that means nothing. they're going to swear on a stack of Bibles that you're too slack. They did send it to you, they're going to say.
So their claim that they sent it to me, even though they don't have any proof, would override my affidavit that was sent certified mail and notarized.
That's right. Certified and notarized don't mean anything at court. It's your word against their word.
Now, this is really a rotten business.
Yep, it means nothing. As far as they're concerned, the judge is going to say, well, these attorneys are good, godly people, and they're members of the Bar Association. They're honorable people, and they would never lie.
They're not.
Anyway, you don't need to get in an argument. He's making the point.
You're making a point, but they've already been condemned by the state of Idaho and fined $4,000 for their bad procedures.
You don't know to go down there and physically hold that court case on your hand and thumb through it to your hand or ask the man.
I will do that. I'll do that. I know, but all I'm saying is that may be something that we can use also, because we checked the guy out in the state of Idaho, and he was fined $4,000 for doing bad.
Let's move on. Okay, you're going to go down to the mall and make sure there's a certified. You're going to make sure what the paperwork that you have in your hand matches exactly what the court case file has in their hands, okay? And if it isn't, you're going to ask them for a certified complete copy of the case file in chronological order.
Okay.
Okay, that's what you're going to do.
Okay.
Then what you're going to do, if you do find that there's an error, that there's some paperwork that you don't have, that they do have, then obviously you're going to have to do a stay for the proceeding. You're just going to say, well, I'm going to send you the stay of the proceeding. It's going to say 90 days, but the judge would probably say 30 days.
Okay.
Which is fine. And then, like I said, then we're going to go from there. If they have all the bill of particulars or the invoices, and if they have an affidavit from them, and if they have the delegation of authority, the power of attorney to act on behalf of Capital One, then we'll do it from there. If they don't have any of that stuff from there, then you're going to send up a lawsuit for a claim of barratry. And then you're going to go after them for wasting your time, wasting your effort, and wasting all this stuff. You see what I'm saying? But you can't go common law until you're done doing it the other way.
Right. So we're almost going to have to. We're not going to be able to get that lawsuit form tomorrow, would we?
No, tomorrow just get the continuance, and then you form the lawsuit in the 30 days.
Oh, is that right?
Yeah, and then they still have 21 days to answer. So, it's just because you put a lawsuit in tomorrow doesn't mean that they're going to hear the lawsuit tomorrow.
Yeah, but I mean, we couldn't prepare a lawsuit by tomorrow, could we?
Even if you could, they still have 21 days or 20 days to answer that now. So it's pointless.
Yeah.
So what you're going to do is you're going to see what I said to do.
Okay.
Give you the stay of the proceeding thing. All you do is you just cut, copy, and paste it. It's a real simple thing.
Okay. What is that word you're saying? Barratry.
Barratry. It's B-A-R-R-A, like A-R-T-Y. Barratry.
Okay.
So all it means is there's a member of the bar, an attorney, a bar member. And he's bringing in false controversies or false claims or false complaints into the court.
Okay.
That's all it is. You're going to make and that is definitely common law, so it's an easy one to just whip out a, one sentence, two sentence thing for barratry. That he started this complaint, but he's not willing to finish it. He's not prosecuting it, and he's not giving us the evidence in which we demanded.
Okay.
And actually, Carl, if we go down there and our paperwork matches his paperwork, we're still asking for the continuance. Is that correct?
Exactly. Until you can exhaust all the administrative remedies on a private side. Yeah.
Okay.
That's all you're going to do, because you're going to say, obviously, even if the paperwork, like I said, doesn't match, because you just want a continuance. Because, like I said, then you're going to build up a lawsuit. And then you lawsuit already, because that's going to take a week or two to get that all tightened up with all your exhibits and everything. And then you're going to put all your one-page claim in there for barratry against them. And then you're going to, you're going to wrap it all up in one shot.
Okay.
Now, just like I have to mail an answer to the complaint, if I was going to file an answer tomorrow, then I would have to mail them a copy to the opposing counsel. I have to also mail them a copy of the continuance?
If court's tomorrow, they're supposed to be in court. They're supposed to be sitting there waiting for you, and you're supposed to.
They don't do it that way here. Once we file our paperwork, then according to their instructions, that I went down and talked to the court clerk, and she says, once you file you're within the 20 days. When you file, then I will. The court clerk told me. Then I will
set a court date.
That's fine.
And then at that time, you need to file. You need to send your paperwork to the attorney.
Right. That's fine.
So we know that that's the way their procedure is here.
Yeah, I read the instructions that you guys had there. Yeah, I seen what it said that there's to answer to the court clerk, and then she's going to set filing fees, file a fee for your answer. Right.
The other thing that we need to find out now is, and how can we find that out? We need to find out absolutely for sure that the credit company closed the case.
That's fine.
And then we just figure that the attorney just took it over because they.
I'm not worried about that part right now. That's way into the game. All you're trying to do is do the answer them all, and we'll go from there. First, you got to see what's in the case file because you're trying to do 3 or 4 different scenarios at the same time, and it could be so super simple that you got me giving you 5 different answers, and you guys are just going to get really freaking confused because my answer is going to change 5 different times.
Okay, all right.
And you're going to say, well, I thought we were supposed to do this. It's like, yes, if this, and this happened. It's like, but then you told me this. It's like, yes, but this did not.
No, when you first brought it up, you said, we just wanted to make sure because we're positive that the attorneys are just going through with this thing, and I don't even think they got to deal with it.
Find out tomorrow when you go down to the court case house and you grab that case file and you hold it in your hands and keep quiet. Stop telling everybody, well, they don't have this, they don't have that, they don't have that.
Yeah, I understand.
Don't correct the attorneys. Don't help the court clerk. Just keep poker face. Don't say a damn thing. And that way you could actually get a hell of a lawsuit going as long as you don't keep reminding the attorneys how to do their job. They might not actually know how to do their job. This might be their very first thing they've ever done. Just let them think themselves.
Okay, anyway, what's the, being all these liars and cheaters and thieves and all that, now, if they don't have any paperwork in there, and we ask for more time, and then they do put more paperwork in there, how does that work?
If they didn't do it by now, they won't do it then.
Okay.
Don't worry about it. Like I said,
there'll be both of us there, so we'll both be witnesses to the fact of what exactly was there. That's
what I'm saying. So tomorrow when it goes there, if there's only 2 or 3 pieces of paper in there, how many pieces of paper do you think are in there right now? How many pieces of paper did the attorney send you?
They should only be the complaint with 3 pieces of paper.
Okay, well then that's fine. Ask the court clerk if she could certify the complete copy of the case file to this date. And so all you should have is 4 pieces of paper then.
Yeah.
You should have the summons, and you should have the complaint with 3 pages and 1 page, and that's all you should have.
Okay.
If there's anything more than that, and then that way, because you try to provide an answer, and since you tried to provide an answer, now all of a sudden, if 5 pieces of paper pop up in 30 days from now, or 10 pieces of paper, then there's a trial by ambush, and they can't get away with that nonsense.
Karl, I just wanted to say I really appreciate your help. Something as simple as going down and checking the case file, I don't know, and I really could not do this without your help, so I really appreciate it.
Oh, I've done this so many times, it's scary, so I know the tricks that they're going to try to pull on you people.
Okay.
Next thing you know, they're going to have 50, 100, 500 pieces of paper, and you go like, whoa, what's going on? And the clerk's going to say, hey, we got it the day they filed. They sent it to you. They told us they did, didn't you, Mr. Attorney? Yes, we did. Like, well, there you go. It's your word against their word. And they're going to say, well, you're 80 years old, and you must be just going slow.
Yeah.
I'm going to blame it all on you. I'm telling you, man, I know exactly what they're going to try to do. So you get down there first thing in the morning, and you see what they actually got, and you tell the lady they need it certified. She's going to certify it and a complete copy of the case file.
And then we'll
do the continuance.
When you go to the clerk of the court, it's try to remember ACC.
Okay.
It's called Authenticated, Certified, Complete Copy of the Court Case File. It's ACC.
Okay.
It's Authenticated, Certified, and Complete. ACC. And that's all you're going to ask her for. When you say, I need an authenticated, certified, complete copy of the court case file, she's going to say, you know what the hell you're talking about. And don't let them razzle-dazzle and say, well, you got everything there. I said, ma'am, I need it to be authenticated, certified, and complete. I need your stamp on it.
Okay.